Representative Mack.
Here.
Present. Representative Bacala. Representative Bagneris. Representative Carpenter. Representative Cruz. Representative Duplessis. Representative Dwight.
Here.
Present. Representative Gaines. Representative Hazel.
Here.
Present. Representative Hodges. Representative Howard. Present. Representative James. Representative Marcel. Present. Representative Marino. Present. Representative Muscarello. Present. Representative Norton. Present. Representative Pilot. Present. Representative Stefanski. Present. We have 11 members present and a quorum.
Okay, Senator Milkovich, Senate Bill 181.
Thank you, Mr. Chairman and members. Advanced imaging technology, primarily the ultrasound, allows us to see so much more about the unborn baby that we could see 20 years ago, 10, or even 5 years ago. We know now that at 12 weeks, a baby moves away from the metal wand or sensing device that's used in ultrasounds. At 12 weeks, a baby responds to stimuli and pressure. At or before 15 weeks, a baby can be seen grimacing, yawning, smiling, frowning. And basically, in the 15-week bill that was passed in Mississippi, we see that the neurological findings of neurological development include that between 5 and 6 weeks gestation, the heart begins beating. At about 8 weeks post-gestation, the baby's moving about in the womb. 9 weeks, all of the basic physiological functions are present: teeth, eyes. 10 weeks, the vital organs are beginning to function: hair, fingernails, toenails beginning to form. 11 weeks, the diaphragm is beginning to develop. 12 weeks, the child can open and close his fingers, start making sucking motions, and senses stimulation from the outside world. This is what we know. I think what this bill recognizes is that babies are humans. They're just small humans. And we have I believe, moral obligation to protect them. It's not only the fact that we are taking their lives, but it's the brutality of post-15-week abortions. The majority of those abortions are performed by dilation and evacuation, which involves the use of surgical instruments to crush and tear the unborn baby apart before removing the pieces of the dead child from the womb. And we know that the medical complications at 15 weeks are significant. For the post-15-week dilatation and evacuation, it can include pelvic infections, incomplete abortions where part of the baby's left in the womb, blood clots, heavy bleeding, hemorrhaging, laceration, tear, or other injury to the cervix, puncture, laceration, tear, or other injuries to the uterus, injuries to the bowel or bladder, significant injuries, and this is a statement, and we really proud of what Mississippi has done in this instance, but we want to make abortions after 15 weeks, to declare the right of the state to protect life after 15 weeks gestation. Do any members of the panel have questions? I do want to thank you all for your attention.
They do. Representative Pilot for a question.
Thank you, Mr. Chairman. I just wanted to move at the appropriate time, move this bill favorable. Thank you.
Thank you very much, Sheriff.
Representative Marino, is your question for the author?
Yes.
Okay.
Can you explain the part in Section F which talks about the upon final decision of the Court of Appeals of the Fifth Circuit?
Yeah, and Representative Marino, there, and actually that was not an amendment that I personally favored, but in the Senate, there was enough senators voting to pass a provision that says that the bill will go in effect when the Fifth Circuit upholds the Mississippi ban. I would like for it to go effective as soon as the governor signs it, but basically what the thought was is that the Fifth Circuit's going to rule on the Mississippi ban. We think there's a very good chance they'll uphold it. Our law will go into effect when the Fifth Circuit upholds the Mississippi.
It says that the provisions of this section shall become effective upon any final decision. It doesn't say that it has to be upheld. It just says upon any final decision. So the Mississippi court could strike it down, and then what would happen to this bill?
Well, I mean, there could be litigation, and we understand I think part of the purposes in trying to stack it behind the Fifth Circuit's ruling on Mississippi was that Mississippi could spend the litigation costs. But if we have a chance to put this statute in place, we can start saving babies at an earlier date. And this is something we may have to fight out in the courts. And I believe, it's my belief and the belief of, I think, people that have voted for this, is that these babies, the lives of these babies, are worth fighting for in the courts.
The beginning of the paragraph says, shall become effective upon any final decision, but then the end of the paragraph says, which decision would thereby provide the authority for a state within the jurisdiction of the Court of Appeals to restrict abortion past 15 weeks. So, I mean, my only question is, if a Mississippi court strikes it down, does that say that there is no authority of the state to restrict abortion past 15 weeks?
You know, that amendment was not one that I favored, but that does appear to say that our bill is on hold until the Fifth Circuit rules. And I'm open to amendment that says that our bill goes into effect as soon as the governor signs it. So,
well, right, but I'm just trying to straighten out that paragraph. I mean, it seems to me that the intent of that paragraph is to say that this legislation won't come into effect unless the decision is affirmed, the decision of the court.
that was the amendment that was passed on in Senate over my objection.
Right, but it probably should say upon, that type of decision, not any decision, because then it doesn't mean anything. It just means you have to wait until that court decides. But I
Sure.
think what this is trying to do is to say, if the Mississippi court strikes it down to say that the state doesn't have the authority to restrict in the way that your bill does, then I think the language has to be changed in any final decision. Otherwise, it doesn't really mean anything. It's just a delay.
Okay. Well, listen, and if that needs to be clarified between, I hate to use this tried expression, between now and the floor, certainly, I want it to be clear. And I am saying, I want to be very honest with you, that I was against the amendment in the Senate.
Oh,
I
I got
said,
that.
I think we should put it in effect.
Time's up. Okay, Representative Norton.
Thank you, Mr. Chairman. Good morning, Senator.
Yes, Representative.
Good to see you from North Louisiana.
Yes.
Just a quick question for you. Are there any data or information that validates how many abortions has happened after the 15 weeks at this particular time?
There probably is. I do not know the answer to that question, Representative Norton. I can tell you that right now it is legal to kill, to take the lives of the unborn babies after 15 weeks. But how many of those post 15-week abortions are being performed in Louisiana at this point? I don't know.
Is there any data that states on behalf of the medical fields that say maybe after the first 5 weeks or 6 weeks it should happen, or you just felt that the 15 weeks would be sufficient in order to do this?
Well, of course, you know me well enough, Representative Norton. I've known you for many years, and by the way, for those that you don't know it, Representative Norton is a political juggernaut in Shreveport, Northwest Louisiana. I've known her for a long time. My belief is I would love for us to get to the point where we can outlaw all abortions, and I think we want to outlaw abortion. I do, and I feel like there's people in Louisiana that do. The longer the pregnancy goes, the more risks there are to the mother, of course, medically, and the more tortuous the procedure is for the baby. Of course, that's a neurological belief. It's hard for us to know how the baby feels, but we feel like the further along it gets, the further along the pregnancy gets, the more heinous the act. And these babies, when you take them post 15 weeks, again, it's the dilation and evacuation. You're basically taking the baby and dismembering it, and that's not even just killing. That's, as we have said on this bill, torture.
And I certainly want to go on record stating that I'm not saying that I'm for getting rid of all abortions, because there are emergencies and there are situations to where it needs to happen. But at the end of the day, I was going to move your bill. But thank you so much, Senator, and thank you, Mr. Chairman.
Thank you very much, Representative Norton. Thank you for your questions.
Representative Marcel.
Thank you. Senator, question. In your bill, it says that you're going to retain the present law. Is it also going to retain the law where the doctors, in order to save a life, can perform an abortion? In Part 2, I'm looking in your digest, number 2, on page 3. Is it going to retain that? The physician terminates the pregnancy for the express
This actually does not address that specifically. So,
but I guess my question is,
I think it would say that. I'm sorry.
my question is the proposed law going to include this part of the present law? This is currently the law now, as it states, as it stands without your bill.
Sure.
So my question is, will your bill do anything to change that? If a physician feels that it's life-threatening for the mother, or to save the mother's life, and they perform this procedure, would your bill affect that?
It may, because this bill does not recognize, and I think you're asking about exceptions. This
Correct.
bill does not recognize exceptions after 15 weeks in its present form. It does not. To answer your question directly.
And so, is it your belief? I know you said you want to outlaw abortions, but is it your belief that in the situation where the doctor has to choose to abort the baby or to save the mother, that they shouldn't abort the baby and the mother could possibly die? Is that your position?
Well, no, not exactly. I think my position is this is a total ban after 15 weeks, and you are right about that. This is my thought about this, because we've been having this debate and discussion for 20 years or longer, 30. I believe that the abortion industry has really injected this dynamic into the debate. How many documented cases do we know that it's actually necessary to kill a baby to save the mom? And
I don't know, and
Sure.
that's not my point.
Sure.
My point is it is an exception in the law for a reason, because if the doctor has to choose to save my life or to abort the baby in order to save my life, most people would want to abort the baby to save the mother's life. Most people, if you did a survey, I believe that, and that's why the exception is there. And so if your bill does not include the exception, that presents a problem for me.
Okay.
That's A. And B, let's talk about the Fifth Circuit for just a second.
sure.
If, in fact, the Fifth Circuit finds that it is unconstitutional what they've done in Mississippi and they strike it down, then why wouldn't your bill say only if it's upheld? Because if it doesn't say that, that means that we will be going against what the law is. And so why do we Louisianians want to set the pace or the scope that we're going to pass a law that the Fifth Circuit has stricken down as not constitutional?
You know, I believe this. I believe that we should not refrain from doing the right thing today as legislators, because the federal courts may do the wrong thing tomorrow. I believe further that these unborn babies, this is a fight worth fighting. We fought a lot of battles in the last couple of years, controversial battles, and I think that if we need to challenge some rulings in federal court on behalf of our unborn babies, I think the cause is worth the fight. And to finish,
I don't
I'm
mean
sorry.
to cut you off,
Go
but I'm
ahead.
running out of time, and I got
Okay, I'm sorry.
one last
I'm sorry.
question.
I'm sorry.
Who determines if it's a doctor? Who determines if it's 15 weeks or it's 14 weeks? So if somebody performs an abortion at what they believe to be 14 weeks and is later determined to be 15 weeks, how does that work? Because they are the physicians. So help me with that piece. And then that's my final question.
Absolutely. I believe that, and of course we have some other expert witnesses to address these questions, but I think it does put a burden on the doctor to make sure that he's not killing a baby at 15 weeks. And yes, that would put the burden is on the doctor.
And let me say, I'm all for saving babies' lives, but after I
Yes.
save them, I'm also for providing for them after they get here. So let's keep that in mind. After we save them, we need to put some money in the budget so they can get through K through 12 and they can have health care and all of that. So I'm all for that. It look like me and you on the same team. Thank you for your
We
bill.
had the same conversation, same place last year.
Thank you.
Thank
All
you
right,
very much.
We also have
Representative Marshall.
some filling out cards in support who wish to speak. Mike Bourgeois from Baton Rouge, and Richard Mahoney, also from Baton Rouge. If you guys would come to the table. Okay, Mr. Bourgeois.
I'll defer to Mr.
Okay, Mr. Mahoney, you got 3 minutes.
Okay, my name is Richard Mahoney. I'm a respiratory therapist and work in cardiopulmonary. I am called to high-risk deliveries all the time. I'd like to clarify a few things about this. I was hoping that Senator Milkovich would show you the silent scream done by Bernard Nathanson, who was the founder of abortion in this country. He presided over 65,000 abortions, killed his own child, then saw an ultrasound of an abortion with a child frantically fought and screamed while it was being killed as a 12-week-old baby. We need medical facts here. And for your question, in the medical field, I've been called to thousands of deliveries of 1 and 2 pound babies. No doctor in this state kills a baby to save the life of the mother. He's got 2 patients. One's the baby, one's the mother. If you, in the treatment of the mother, the baby dies, that's not an abortion. This is the Criminal Justice Committee. The leader of the abortion cartel in Louisiana is Leroy T. Brinkley, who lives in Philadelphia, Pennsylvania. Look up the chronological history of Delta and all the abortion clinics he's owned and the crimes he's committed. Are you going to trust the women of Louisiana to this man? And it's the duty of the parents to provide for the children, not the state. This is not the truth. You know, I've been listening to a lot of committees, and it's about truth and transparency. Look up the facts. The abortion cartel, Lisa Harris, just testified. While she was 18 weeks pregnant, she was ripping a baby apart that was 18 weeks old. And every time she pulled a leg or arm off the baby in her womb kicked her. And yet she still believes the right to kill a baby. Dr. Hayward Robertson, who presided over abortion, he said it's madness. I kill a baby in one room, I deliver a baby in another, then I go to NICU to try to save babies. This is madness. You want to know the truth about dismemberment abortion? You want to know the truth about abortion after 15 weeks? These people don't care about women or children. It's paid assassins, paid murderers. Get the truth. Go look at the chronological history of Delta, Leroy T. Brinkley, and what has gone on in this state. And then go to the medical experts who treat the mother and the baby, who don't get paid to kill 30, 40 babies a morning, rip them apart, throw them in the trash, and commit every other violation against law and medicine. Dr. Bernard Nathanson in the silent scream said, this is medical and ethical dishonesty. I started abortion in this country. I lied, I perjured, I took a woman, paid $10,000 to that woman to say that she wanted an abortion. She wasn't even pregnant. It's all based on a lie. And the state can't uphold this lie.
Thank you, sir. Thank you. Mr. Bourgeois,
Yes,
3 minutes.
I would like to address one of the major concerns about this bill, and that concern is a false concern for this reason. In the Dred Scott decision of 1854, the Supreme Court said that enslaved Africans in America, and that ruling was called a decision, have no rights because they're not legal persons, which later on, that took the Civil War, the Emancipation Proclamation, and the 14th Amendment to overrule that. The Supreme Court has never even apologized to anybody for that. Fast forward to 1973, they doubled down and said nobody in the womb has any rights because they're not legal persons. They re-legalized Dred Scott. But Harry Blackmun, who wrote the majority opinion, said, this is our opinion. This is not settled law, Neil Gorsuch. This is an opinion that was changeable on certain conditions that is written into Roe v. Wade. And that is, even if the suggestion of personhood comes into the picture. That, quotes, collapses Roe v. Wade and, quotes, guarantees 14th Amendment rights to those in the womb from conception. Well, not only did that suggestion become science in 1984, when DNA fingerprinting came into existence in 1984, it proved that life begins at conception at that instant because the DNA in the egg and the DNA in the sperm recombine and a new person is born with its own DNA profile for life, whether that ends in the womb or over 100 years out of the womb. So the collapse of Roe v. Wade scientifically, according to Roe v. Wade itself, came in 1984. So when is the legal collapse going to take place? The Supreme Court cannot do that, what y'all think it's going to do. If it turns it over to the states, you know what they'll be doing? Would that bring the country together? That would divide the country into modern-day slave states and free states all over again. There's no telling how long this division would go on after that. And there will always, the multi-billion-dollar abortion industry has a set group of objections that they use when somebody says life begins at conception. The first one is that it would end artificial birth control. Well, if you look at the Hobby Lobby decision from the Supreme Court, they said that only 4 of them would not be able to be used. You got 16 birth control pills. It's all a lie. This should have been handled since 1984. That's 40 years ago or 30 years ago.
Thank you, sir.
What are we waiting for?
Thank you, sir. Thank you, sir.
Let's base it on fact and evidence and science.
Wayne
not political
Gravings? Is it Wayne Gravings?
Gravois.
Gravois, I'm sorry.
Okay.
Okay.
I've been called worse.
3 minutes.
I'm Wayne Gravois, family physician. Just a quick history on me. I finished the LSU Medical School in 1981. 34 years of family physician, practiced in a local community just north of Baton Rouge and Zachary for 28 years. I've been at the medical family medicine residency program the last 6 years, and I'm here to represent myself and my profession. Nothing to do with any of the locations I practice now or the students that I teach at universities. Again, I want to emphasize that I'm here to represent my profession, family physician. The thing I wanted to talk about, other qualification is I'm in addition to taking Hippocratic oath back in 1981, which states first do no harm. I've tried to live by that for the 34 years of practice. I'm the medical director of the Pregnancy Problem Center here in Baton Rouge. It's a counseling center, education center for women that are either pregnant or considering pregnancy or immediately after their delivery. And they'll come in for various problems. We try to encourage the father to also come in. We try to counsel both on decisions in the future, whichever they decide. We do volunteer. We have volunteer ultrasound techs that come in and do ultrasounds on a regular basis, at least once a week, on women that are pregnant. The ultrasounds are done at all ages, as early as 6 weeks all the way up to right before delivery. These women, again, oftentimes have decisions that they're trying to make, whether it's going to be abortion, adoption, and we try to counsel them on that. One of the things that I wanted to speak about was the direct discussion on the bill itself. Again, I don't represent anyone but myself and my profession as a physician. 3 weeks ago, I did not know Senator Milkovich. I contacted him myself. So I want you to understand that this is not any incentive by me to be here other than to what I feel to discuss what I think is right. children, they'll call them fetuses, embryos, whatever you want to call them, at 15 weeks. I'll call them children because if you see a 15-week ultrasound, it's a baby. They're fully formed. They yawn, they smile, they grimace, they move away from the ultrasound probe. I would encourage anyone that has a decision to make, not make a negative decision on the bill until I've seen a 15-week ultrasound. I think that is imperative if you are against the bill. The baby feels you can get any expert across the country to say anything you want, but there's no question. I've seen enough of them. We have an ultrasound tech that's got 30 plus years of practice, and I've spoken to her on multiple occasions. 15-week children in the womb feel. There's no question in my mind. So if this bill,
Sir, you got about 30 seconds.
okay. So in final, I'd just like to add closing. I'd like to have everyone just think that what's the right thing to do in this bill. I'd be happy to talk to anyone afterwards. Thank you.
We do have a question for you, sir, Representative Moreno.
It's just a brief question. The Mississippi law says except in medical emergency. How does medical emergency play into, if you add the phrase medical except in a medical emergency, what does that do to your role as a physician?
First off, again, we practice Hippocratic oath. I think any physician that doesn't do that, I question, but it would be in the best interest of the mother and the baby. There's present law, I just was informed, that actually states that it shall not be a violation of subsection C, etc., in reasonable medical judgment to prevent the death or substantial risk of death due to a physical condition or to prevent the serious permanent impairment of a life-sustaining organ of a pregnant woman. However, the physician shall make reasonable medical efforts under the circumstances to preserve both the life of the mother and the life of her unborn child in a moment consistent with reasonable medical practice. And as a physician, I would hope that would continue. So again, we talk to the residents all the time. We have all these algorithms, and it says, you do this, if this happens, this happens. As a physician, you have to practice out of the box sometimes. You have to make decisions, life-making decisions last minute. And this particular part of the present, standards or policy by the state is what I would want to uphold if that answers.
All right. Thank you, sir.
This would never occur in an abortion clinic. If there's a medical emergency,
sir,
we do it at the hospital.
We're going to yield the table to Mr. Clapper. Mr. Clapper, you have 3 minutes.
Yes, sir. Ben Clapper, Executive Director of Louisiana Right to Life. We support this legislation. I want to just answer a couple things, provide some information. First, in 2016, there were 461 abortions at 15 weeks and later in the state of Louisiana. So that was about between 8,000 and 9,000. I can't remember the exact number right now. Total abortions in the state. So that's 461 babies that lost their lives due to abortion in 2016. Representative Moreno, the question about the Section F, about the trigger on the Mississippi law, I think the end of the sentence assists in clarifying, which we can talk about afterwards if you like, where it says, so it says any decision, and then at the end it says which would thereby provide the authority for a state within the jurisdiction of the Fifth Circuit. That's what makes this possible, is that we're within the jurisdiction of the Fifth Circuit. So whether Louisiana defended the law, it's not going to go into effect here because it will immediately be sued and the court would enjoin the law. So Mississippi proceeding with the defense helps Louisiana, since we have about 6 pro-life laws that we've passed over the course of the past 3 years that are currently in defense in federal court that Louisiana is defending, and our Attorney General is doing a great job on it. Also, I was going to answer Representative Marcel. So, Dr. mentioned this as well, but this bill points to RS 40-1061, which is in our abortion code, which clarifies the language that he mentioned, Representative Marcel, about emergency. Not putting you on the spot, so just... That's all right, very good. So it's clear that what happens in the case of a medical emergency already in statute right now. And I have that information. You just read it, so I don't need to read it again. And it's clear that in the case of the medical emergency, which would mean the death or substantial risk of death of the woman, that's right. And also, but the physician shall make the reasonable efforts, which Mr. Mahoney was getting at. The physician shall make reasonable efforts to save the life of the baby and the mother in the situation, always keeping both in mind as best as possible. So I think that answers the question. Now, there in the Senate, the version of the amendment that was put on, there needs to be a small technical tweak, which I'm going to talk to Representative Milkovich between here and the floor about that as well, which is in that part that you're talking about to clarify it, even make it stronger and clear.
Okay, thank you, sir. Also filling out cards in the support who do not wish to speak is Dr. Will Hall, Louisiana Baptist Office of Public Policy, and Gene Mills, Louisiana Family Forum. We do have opposition who wish to speak. It's Lakeisha Harris, Women with a Vision. Are you in the chamber? Come on up, ma'am. Amy Irving of New Orleans.
I'm Ellie Schilling. I'm an attorney, and I have several medical providers with me. If we could go first.
You're going to need to fill out a card.
I did fill out a card.
I don't have it. You fill out a red card?
Ellie Schilling.
Oh, I do have it. That's good. Okay, Miss Schilling, come on up. Does Miss Harris not wish to speak?
Yeah, I do.
All right, well, come on up.
Is it all right with you? We have sort of decided on an order. Is that
Well,
okay?
I'm on the side of the order. Won't you come on up? And then Angela Adkins. Are you in the chamber? Miss Atkins, come on up. Okay, Miss Schilling. You want to go first?
I think my colleague here is going to go first. Actually, I'll go
And you're
second.
Miss
Thank you.
Harris?
I'm Dr. Quanslarie.
I don't remember calling you.
Oh, I'm sorry.
Okay.
Do you-
Miss
Do
Schilling.
you have my card?
Well, I'm going in order as I got the cards.
Okay.
And so I tell you what, you're already at the table. Why don't you go ahead? But we're going to take them in the order that I called, okay? We got a lot of bills today. And I want to hear your side of the story. And trust me, I'm not trying to, but we got to keep it in order. So you go ahead, tell us who you are. You got 3 minutes.
Thank you, Representative. Greetings, members of the House Committee. My name is Dr. Anna Quanslarie, and I am a resident of New Orleans and training to be an OBGYN. As a woman and as a physician, I wanted to be here today to oppose Bill 181, a ban on abortions after 15 weeks. As a physician who specializes in women's health, I care for women in all stages of life. This includes women facing unintended pregnancies or pregnancies that occur at the wrong time or with the wrong person. This bill ignores the unique real-life situations as well as health issues that patients face in pregnancy. Individualized and personalized care are the cornerstones of my relationships with my patients, and I know that every patient and every pregnancy is different. I work in a very busy hospital, and I have had the privilege of caring for a huge number of Louisianians. My patients are strong, and they are persevering, but they face innumerable challenges in their everyday lives. One patient I think about constantly is a 15-year-old in the 10th grade. She and her boyfriend had sex, and then afterwards realized that the condom had broke. When she missed her period, she didn't know who to talk to. She was worried that her mother would throw her out of the house, knowing that she had other brothers and sisters to feed, and there was no room or money for another hungry mouth. She waited until her belly was noticeably growing before asking her mother to take her to the doctor, at which point she was already 20 weeks. She had no choice but to continue this pregnancy. When she went into labor, her young face told me that she was terrified of what her body was going through and also of the challenges of being a mother. She had already faced innumerable challenges in accessing care, and now she faces the terrifying reality of motherhood. I have continued to see her, and I know that she's trying to finish school. But it has been hard to arrange childcare. She and her boyfriend eventually split up, and she plans to enter the workforce after school to provide for her child. Maybe she'll go to college after the child is grown up. Patients like her, considering abortion, already face very challenging circumstances. They deserve evidence-based, supportive care individualized to their unique needs, and Bill 181 directly interferes with my ability to support a woman's comprehensive well-being and to provide safe abortions. I am also concerned that this bill has no exception for many unique medical situations. For example, my colleague recently cared for a patient who discovered at her routine 20-week ultrasound that the baby had not formed a head correctly. She was told that the baby would die shortly after delivery and had no chance for survival. Due to local state policies already in place in Louisiana, she was forced to continue this pregnancy to term. As her belly grew, she encountered many of the typical reactions of friends, family, and community members. When are you due? Is it a boy or a girl? Congratulations, you must be so happy. They would say as they reached out to touch her belly, constantly reminding her of the sad inevitable outcome and leaving her at a loss for what to say to them. How could she explain to her 2 young children that they were not going to be getting a new baby brother or sister? It is impossible to predict the far-reaching consequences that Bill 181 will have on the lives of patients. 15 weeks is too early to diagnose many fetal malformations, and this bill will prevent innumerable women from having the option not to carry a pregnancy that will ultimately result in a baby that may not be able to survive outside of the womb. Individuals just like these 2 women live from Shreveport to Baton Rouge, from Monroe to New Orleans. These women, they are students, they are athletes, they are professionals, they are hardworking women, they are caregivers, and some of them are dependents.
Okay. Yes, ma'am.
They are our neighbors, coworkers, friends, and children of our friends and their family. What they have in common is challenges accessing the full range of reproductive health care options in Louisiana, and Bill 181 will represent yet another barrier to them. As a doctor who cares for the women of Louisiana, I strongly oppose Bill 181.
Thank you, Doctor. Thank you for coming to the Capitol. Miss Schilling.
Yes, thank you, Committee.
3 minutes.
My name is Ellie Schilling, and I'm an attorney who advises and represents reproductive health clinics in the state. There's been a lot of discussion in the past few weeks about whether this bill is constitutional and about what the legal cost could be to the state if the state passes it in terms of defending it. So I'm here to provide a legal perspective today on those issues. First, a 15-week ban is a pre-viability ban, and a pre-viability ban has never been upheld by any federal court. A pre-viability ban has never been upheld by any district court or any appellate court in the country. Pre-viability bans have been struck down in North Dakota, Arkansas, and Arizona. And in Arizona, it was a 20-week ban that was struck down, which is the ban that we already have in place in Louisiana. It is settled U.S. Supreme Court law, not only from Roe, but also from Casey and from Whole Women's Health, that a pre-viability abortion ban will not be upheld. The decision in Casey is a 1992 decision, so I'm not sure what the testimony was before about something having changed in 1984 that would overturn Roe. Casey was much after that, and it reaffirmed the holding in Roe, and specifically said, before viability, the state's interests are not strong enough to support a prohibition of abortion or the imposition of a substantial obstacle to the woman's effective right to elect the procedure. Therefore, while some restrictions or regulations prior to viability may be constitutional, a prohibition on abortion before viability is unconstitutional, which is why the 15-week ban that was recently passed in Mississippi, as we've been talking about this morning, has already been struck down by the courts. Within 24 hours of the governor signing it, then that law was blocked, and it will remain blocked pending a trial. There's no reason to believe that the Mississippi law or SB-181 will be upheld by the courts, the Fifth Circuit or in Mississippi. Now, in an attempt to insulate SB-181 from legal challenge, the bill has now been amended to state that it will not go into effect until the Fifth Circuit upholds Mississippi's law. There's several problems with this strategy and why it will ultimately fail to save the state a costly legal battle. First, even if the Fifth Circuit were to uphold Mississippi's law, that would be before the Supreme Court had weighed in on the constitutionality of a pre-viability 15-week ban. So our law would immediately go into effect, and it would immediately be challenged while the Mississippi bill, winds its way up through the appeals process. So it would already be a costly legal challenge for Louisiana immediately then. SB-181 is also a more severe and therefore more unconstitutional law than Mississippi's law. So even if the Fifth Circuit were to uphold Mississippi's law, which is very unlikely, then that does not mean that SB-181 would be constitutional. There's several reasons that our bill is more extreme. First, the Louisiana law imposes severe criminal penalties, while Mississippi's law has no criminal penalties. The Mississippi law also has an exception for severe fetal abnormalities. Our law would not have that exception. And lastly, Louisiana's law calculates gestational age from conception and not from your last menstrual period, which is not true of Mississippi's law. That's a scientifically inaccurate way of calculating gestational age, and it would lead to a far earlier ban effectively. It would effectively lead to a ban more like around 11 weeks, because when you're calculating from last menstrual period, it's later than calculating from no one knows when conception is. So there's also no guarantee that this amendment is going to stick. You've heard Senator Milkovich say that he would prefer that this amendment were not on the bill. He would prefer that the bill goes into effect immediately. So if the amendment is removed, Louisiana will be back in the situation of immediately having a costly legal battle. Senator Milkovich has said that he's okay with the state spending millions and millions of dollars to try to defend this unconstitutional law. But the state is already spending millions of dollars trying to defend laws like these. There are 6 different pending litigations right now in Louisiana on abortion restrictions. In 2016, all 7 of the restrictions that were passed are being litigated. One of those actually is a dilation and an evacuation ban that has been described earlier. That's already on hold in Louisiana. If the legislature would instead prioritize legislation that would help the women and families of our state, increasing access to affordable health care, improving our foster care system, funding top scholarships, if the legislature prioritizes programs like that rather than prioritizing legislation that will be overturned by the courts, then we could fund better and more effective services for the citizens of our state. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Schilling. Ms. Harris?
Yes.
3 minutes.
Thank you. I want to start by thanking the House Criminal Justice Committee for agreeing to make space for me to enter my voice and discuss how this bill will drastically hinder the lived experience and lives of the women in my community. I am Lakeisha Harris, and I am the Reproductive Justice and Sexual Health Program Manager with Women with a Vision, Inc. I have spent most of my life advocating for the most vulnerable members of our society to have access to their medical care needs, starting out as a certified nurse's aide in high school and then moving on to work as a labor support, postpartum and abortion support doula in my communities. Through these intimate interactions with women as their friend, advocate, and companion in care throughout their lifespan, I can tell you that the circumstances that make up our lives are complicated at best and painstakingly critical in the worst of times. No woman that I have ever met takes abortion lightly. There is much thought that goes into the planning to access this medical service. As it stands, a woman has to travel to the mere 3 clinics that exist in our state of Louisiana, making transportation a major and expensive obstacle to care. Further, according to Lift Louisiana, the abortion itself can cost anywhere from $500 to $850 onward. And if traveling, there is also a need for meals and possibly a hotel stay, depending on the location of the abortion clinic in proximity to her home. As I sit before you, not needing an abortion, I can tell you my own anxiety levels go up just imagining what my sisters and fellow community members experience when having to face the tumultuous task of financially planning an abortion. I bring this cost analysis up because, much like our lives, cost matters. Coming up with the funds and collateral costs is already insurmountable work for poor working women, given the 20-week restriction. Lessening that by 5 weeks would essentially render members of my community the abortion option null and void. At 15-week ban means little to those whose bodies aren't connected to the necessity of an abortion. It might mean even less to those who are disengaged to paycheck living. But let me tell you, it means everything to those of us who defer rental, light and gas, and even food payments, because feeding another child on less than a living wage would entrench them in even more poverty. I cannot begin to tell you how many times within our offices at Women with a Vision that we've passed the proverbial hat around to help women who are seeking abortion, already scampering with the 20-week ban. As we continue to be a mainstay for resources in New Orleans.
Ma'am, please finish up.
Yes. For those seeking abortion services, this is a preposterous ban, and it puts them in more of a crisis stances, sending a clear message that their right to life does not matter. I would really love that if you would consider disrupting this harmful legislation and voting this measure down. Thank you.
Thank you, ma'am. We have Miss Amy Irvin. Ma'am, you want to come to the table? Angela Adkins. Ma'am, are you here? Miss Atkins? Okay. And is it Elena? Christens. I thought it was a B. That's okay. Elena Christens from New Orleans. Okay. Okay, Ms. Atkins, you want to go first?
Yes, thank you so much, Chairman
3
and
minutes.
committee members. My name is Amy Irvin, and I'm the Executive Director of the New Orleans Abortion Fund. The New Orleans Abortion Fund provides financial assistance to women who cannot afford the full cost of abortion care. Working with local medical providers, we provide compassionate and empowering assistance to women seeking abortion and distribute pledges as available. Today, I'm here to testify against SB-181, an especially cruel and dangerous bill that endangers women's lives by withholding vital health care after 15 weeks. Senator Milkovich's bill blatantly ignores longstanding Supreme Court precedent established in Roe v. Wade and reaffirmed most recently in Whole Women's Health versus Hellerstedt that guarantees the right to decide whether to end or continue a pregnancy, a decision central to a woman's personal dignity and agency. Last week, Louisiana senators voted to strip nearly 1 million Louisiana women of reproductive age of their rights to bodily autonomy and self-determination, while ignoring the needs of women in their home districts who need abortion care. It's unconscionable for elected officials to relentlessly shame, judge, and punish women who need reproductive health care. Women are moral agents, and we must respect their right to follow their own conscience when making moral decisions. Louisiana legislators on both sides of the aisle claim to support women, but fail year after year to enact laws that would actually make raising families easier. Louisiana ranks last for equal pay for women, but legislators failed to pass a single equal pay bill this session. Two-thirds of minimum wage workers are women, but legislators voted down legislation that would have allowed a raise to $8.50 over 2 years. Disingenuous concern and repeated failure to enact progressive policies explains why Louisiana ranks last in the nation for women's overall economic and social well-being, according to a recent study. The New Orleans Abortion Fund was founded in response to federal and state laws restricting insurance coverage of abortion care. Since then, this legislative body has put political ideology over sensible public health policy and passed legislation requiring clinics to have medically unnecessary admitted privileges, a law that ultimately led to a clinic closure, a ban on the most common second trimester abortion procedure, and a 72-hour delay. In 2016 alone, 7 anti-choice bills were signed into law, all of them currently being litigated at the cost of Louisiana taxpayers. The New Orleans Abortion Fund was started and now supported by many capable women who have had an abortion and who vote. Additionally, our clients are strong, self-assured people who have made the decision to have an abortion after careful consideration of their physical and mental health, family needs and finances, and plans for their educational and employment futures. 70% of our clients already have children. They are well aware of the impact of pregnancy and parenthood on their lives and are worthy of our support and respect in their healthcare decisions. Women should be able to exercise their moral and legal right to terminate a pregnancy without obstacles, including arbitrary time constraints.
Time's almost up.
Almost finished. Yesterday, sorry. Back page. Women are equal to men and deserve to live their lives to the fullest potential. Autonomy, self-determination, and agency are not values just for men or people in power, but for everyone. Louisianans deserve better from their lawmakers who represent us. On behalf of our clients, members, supporters, and donors, I urge you to vote no on SB-181. Thank you.
Thank you, ma'am. Ms. Atkins?
Hello. Thank you, Chairman Mack.
3 minutes.
Members of the committee. My name is Angela Atkins, and I am the Director of Operations for Delta Clinic of Baton Rouge, here in Baton Rouge, and Women's Healthcare Center in New Orleans, 2 of the 3 remaining abortion clinics in this state. I took that position last September because as an advocate prior to that, I wanted to do more for the women of this state. And I am here today to speak on behalf of those women that I talk to every day when they call my clinics and they come through the clinic doors for health care services. Several of you have asked, and Representative Norton in particular, about data. There is a system called LEERS, L-E-E-R-S, that all abortion clinics have to enter the data for abortions into the state system, and that is run by the DHH. For the record, since my clinic was called out by Mr. Mahoney, Women's Healthcare Center passed its annual survey or inspection by DHH earlier this year with no deficiencies. It also passed the health department inspection. In Baton Rouge, we this year have passed our health inspection. Our last visit from DHH was in, I believe it was October or November for Delta, and that resulted in no deficiencies. I take very seriously what goes on inside these 2 clinics, and the services that we provide for women are absolutely necessary, whether they're 5 weeks, 10 weeks, 15, or 19 weeks. When you say that you want to outlaw all abortion in this state, what you're saying is you want to outlaw legal and safe abortions, because you will not stop abortions. Abortions have been in existence forever, since women first began conceiving. We do not, I would hope not, anyway, that anyone on this committee or in this entire body would want to see us go back to pre-Roe days, where women were found in bloody pools in hotel rooms and back alleys. Would you want to have a very technical experimental brain surgery done by someone who was not extremely qualified?
Time's almost up, ma'am. You go ahead and close.
Sure. In closing, women are going to do what women are going to do, and I think it would behoove us to make sure that they can receive a safe abortion from a doctor in a safe facility of their own choosing, of their own volition. My patients make up their minds long before they come through the doors of the clinic, and their decision is made in conjunction with speaking to our doctors and maybe their own doctors or their clergy. I would thankfully hope that you would vote against this bill and allow women to make their own choices with their own doctors.
Thank you, ma'am.
Thank you.
Alana Carson, I'm Miss.
I'll state it. Thank you, Mr. Chairman and members of the committee. My name is Alana Karstens.
Okay.
I am a third-year medical student here in the state of Louisiana. Thank you for welcoming my testimony in opposition to SB-181, a ban on abortions after 15 weeks. This proposal, if enacted, would force a woman facing medical complications to wait until her condition becomes life-threatening, significantly increasing her risk of severe injury or death. The ban would prevent providers from administering critical treatments and require them to deny crucial medical care for a woman until her health crisis becomes life-threatening. This extreme policy callously endangers women's lives and forces providers to violate their professional principles by withholding vital care. Louisiana's unacceptably high rate of maternal mortality will only be worsened by this bill. I am additionally concerned that a ban at this stage of pregnancy would force physicians and families to make decisions without all the information they need. 15 weeks is too early to diagnose many fetal anomalies. Under the current recommended guidelines, based on standard embryology data, testing such as an ultrasound to diagnose anatomical anomalies of a fetus is not effective or even useful until around 18 to 20 weeks of gestation. As such, this law would require a woman to carry a pregnancy to term and give birth to a fetus with little or no chance to survival, as we heard previously. It should also be noted that according to the CDC, their report in 2014, only 7% of abortions were performed between 14 to 20 weeks in the United States. Proponents of this bill will tell you that this is about protecting the health of the women carrying the pregnancy. Respectfully, I have to disagree, and I am not alone. A new report from the National Academies of Science, Engineering, and Medicine examined the available evidence on the safety and quality of different abortion methods, health facilities, and types of clinics, as well as the potential physical and mental health impacts on women. The findings showed that legal abortions, whether by medication, aspiration, D&E, or induction, are safe. Serious complications are very rare and occur far less frequently than during childbirth. Proponents of this bill will also tell you that a fetus at this stage can feel pain. However, according to the American College of Obstetrics and Gynecology, representing more than 57,000 OBGYNs and partners in women's health, has stated that a human fetus does not have the capacity to experience pain until after viability, which is around 24 weeks. Researchers who have studied this have based their conclusion on evidence that connections from the periphery to the cortex, which are required for conscious perceptions of pain, are not intact until after 24 weeks. Viability cannot be presumed based on gestational age.
Time's almost up. So.
All right. Or other single factors, and must be determined by a women's doctor on a case-by-case basis. And only medical providers have the knowledge and skills necessary to assess patients and determine what their medical procedures are safest and best. I would like to close by saying that we should really adjust our focus here in Louisiana when it comes to women's health. We must advance measures that reduce the difficulties that women are currently facing in accessing reproductive health services, including comprehensive sex education, affordable contraception, and safe and legal abortion care early in their pregnancies.
Thank you, ma'am. Representative Carpenter, is your question for one of the witnesses?
For the senator.
Okay. All right. Also, thank you, ladies. Thank you. Welcome to the Capitol. Also filling out cards in opposition who did not wish to speak is Jane Bergen, ACLU, Louisiana, Dr. Valerie Williams, Physicians for Reproductive Health, and Michelle Ehrenberg, Lift, Louisiana. There was also a supplemental card in support from Gideon Rossman from Greenville Springs, Louisiana. And Representative Carpenter has a question for the author of the bill.
Yes. Thank you, Mr. Chairman. Representative Carpenter.
Thank you, Mr. Chairman. Senator Milkovich, just some quick questions, if you will. Do you believe that women have the right to make decisions about their own bodies?
I do. And if you're asking me if I believe that adults have the right to decide to kill unborn babies, though, the answer is no, because I think I believe the reality is that an unborn baby is not just another part of the anatomy. It's not just an ankle or a toenail or a shin bone. It's actually human life. So if your question is, do I think that we each of us as children of God have some autonomy? Yes. Do I believe that means that we can kill unborn babies outside the law in violation of the sixth commandment? I do not.
My question then
Okay.
leads to the fact that many women don't always become pregnant by design. There are victims of rape, victims of incest, and such. And so, given that, I ask the question again, do they have rights to their own, to make decisions about their own bodies and what they will be faced with, for instance, in those situations?
Representative Carpenter, I do not believe that we have a legal, moral, or God-recognized right to kill unborn babies. So I guess the answer is no. Because if you believe, as the Bible teaches us, that humans are made in the image of God, and that thou shalt not kill, and these unborn babies, I understand they're very small and they're not completely formed. They're small human beings. So that, I guess, is my frame of reference.
Okay, my other question then to you is, there have been instances, and it's been cited here by some of the medical professions, and I know of a number of situations where women have been forced to carry babies to delivery. And I don't want to say full term because medical tests have shown that perhaps the fetus is not survivable beyond the womb. And because of the law, and they've been forced to carry the baby and deliver it. And it has caused tremendous emotional being to the mom, the father, and other members of the family. And so I'm saying that to ask you, how do you feel about how that woman might feel being caught in a situation as such?
I think that'd be a great hardship. And of course, I think the medical evidence is very clear, though, and it's rarely talked about, but the emotional and psychic devastation on a mom that allows her baby to be aborted and then lives with the regret for the rest of her life. I think when you're balancing the challenge of raising a child in this world versus the knowledge that you've terminated the life of a human being, I believe that the challenges of raising a child are a blessing compared to the fact or the reality of taking the life of an unborn child.
I feel that there might be some women who might disagree with that statement, but that's your statement. And my final concern is, if this bill were to pass.
Yes, ma'am.
You don't think that this would drive abortions underground and to other means, because it's not going to stop it?
I guess we could say that about
If a woman, I feel that if a woman is make that decision, whatever way she plans to do it, she's going to do it. So I'm more concerned about driving it underground in back doors or closets or hotels to be in an unsafe environment and, to me, cause more problems.
I think anytime we make a law that says you shall not do wrong, it's always going to cause people that want to do wrong to try to do their deeds in darkness. But that doesn't prevent us from taking a moral, legal stand for righteousness and doing the right thing and outlawing doing the wrong thing.
Okay, I understand your concept, but I also feel that women have rights. And I think this oversteps that bound to me right now.
Thank you so much. My closing is 45 seconds, Mr. Chairman.
We still have one more question.
I'm so sorry.
That's okay.
Thank you.
Representative Duplessis, 3 minutes.
Hello, Senator.
Yes, sir.
Hi. I'm the new guy on the block, so I'm going to keep saying that until I'm no longer the new guy on the block. But one of my biggest observations in being the new guy on the block has been, people take positions on what they believe in. And this is obviously something that you believe in.
Yes, sir.
So, I've had the great distinction of being appointed to this committee, and there have been some interesting matters that have come through this committee in my short time serving here. Most recently, there's been a lot of discussion around guns, as I'm sure you know. And it's often said by many who are against more laws to restrict guns or gun rights that passing new gun laws will not in any way stop bad people from doing bad things. That's often the position. I don't know if that's your position, but it's something that I hear very often. So I'm trying to reconcile how that thought or that idea can that be reconciled with what you're proposing, which is to restrict a woman's right to choose or to make certain decisions around her health, and how that would stop certain behavior that you're trying to stop. How will more laws stop the behavior that you're trying to stop? That's the issue that I'm having trouble with. I understand you want to end it all together, but it's apparent to me that more laws won't stop it. It's just going to make it less safe. That's an issue that I'm having reconciling as the new guy on the block. So I'd like for you to speak to that, if you wouldn't mind.
Well, I don't think that this law is going to make it less safe for unborn babies. I think this is going to save the lives, based upon the statistics that were given earlier today, of hundreds of babies. So it doesn't make it less safe for them. And it's for them, the unborn babies that are being killed in the abortion mills of Louisiana. That's who this bill is for. But I think it's also for the state. Louisiana ranks in the bottom of many categories. I think for us to rank at the top nationally among those states that protect the lives of the unborn, I think that's a harbinger of blessing for our state. And if you've, and I want to be brief because you all have many other bills, but if you've seen the videos that have been taken in the abortion clinics of the abortionists killing babies, they are human beings. They're small, but they're human beings and they're being killed. So I feel like
I'm not debating that point. My question is around how do laws stop behavior? Because in one argument, it's often said that certain laws will not stop behavior. So what I'm hearing from you is that if this law were to pass, it would stop certain behavior, and we can agree to disagree on that. My second, observation is something that is interesting but also somewhat disturbing, is that everybody that came to this table today and spoke in favor of this bill was a man. And everybody that came and spoke in opposition to this bill was a woman. And I'm troubled by the fact that we are advocating so strongly, not we, because I'm not supporting this, but we have before us people advocating for something so strongly on an issue where you could never be in the position or stand in the shoes or ever have the experience of a woman. So I just want to state that that's interesting and also disturbing to me.
Okay. Thank you. Representative Moreno, do you have an amendment? Yes. Okay. Representative Moreno has an amendment. Ms. Lulla has it. Why don't we let Ms. Lulla explain the amendment? Go ahead.
Mr. Chairman and members, Representative Moreno is offering this amendment, and on page 2, line 7, it's deleting the word any. So subsection F on lines 6 and 7 will read, the provisions of subsection D of this section shall become effective upon final decision of the United States Court of Appeals for the Fifth Circuit.
Representative Moreno has offered the amendment. Is there any objection? Representative James, your question on the amendment? It's on the amendment? Yes, sir. Representative James on the amendment.
For Representative Moreno, why the Fifth Circuit and not the United States Supreme Court? Because we know that it's going to be whatever is going to be appealed. I mean, you know, we can continue to do these things, you know, and I know that this is a very sensitive issue, but, you know, our oath is to uphold the Constitution. And so I'm curious to know why you didn't go with the United States.
I'm just trying to clarify what was already put on in the Senate when they passed it, because apparently this is under review right now in the Fifth Circuit. And that's the same court that has jurisdiction over Louisiana. So just to clarify what that amendment does, I'm just taking out the word any. But I mean, that's a separate amendment to say Supreme Court, but I'm not offering that one.
Okay. Thank you, gentlemen. Okay, Representative Moreno has offered the amendment. Is there any objection to the amendment?
You know, I have just looked at it briefly, and I probably won't take a position until I have a chance to look at it. But I do appreciate Representative Moreno trying to clarify the law, and if I can talk to him between the now and the...
Arthur has no position. Is there any objection to the amendment as offered by Representative Moreno?
Thank you, Representative Bacala.
With there being no opposition, the amendment is adopted. There are no more questions in the queue. Filling out a card, also supplementing a card in support is Nate Moore of Broussard, Louisiana. I think Representative Pilot moved first to move SB-181 is admitted favorable. Is there any objection? Yeah. Representative Cartner objects. Ms. Spivey will take the roll. A vote yes will be to move the matter to the floor. As amended, a vote no will be to not. Ms. Spivey, please take the roll.
Representative Bacala?
Yes.
Yes. Representative Bagneris?
No.
No. Representative Carpenter? No. Representative Cruz? Representative Duplessis?
No.
No. Representative Dwight?
Yes.
Yes. Representative Gaines? No. Representative Hazel?
Yes.
Yes. Representative Hodges?
Yes.
Yes. Representative Howard?
Yeah.
Yes. Representative James? No. Representative Marcel?
No.
No. Representative Marino?
No.
No. Representative Muscarello?
Yes.
Yes. Representative Norton?
No.
No. Representative Pilot?
Yes.
Yes. Representative Stefanski?
Yes.
Yes. Representative Mack?
Yes.
Yes. 9 yeas, 8 nays.
Move bills. SB-181 is amended. Moves to the floor.
Thank you, Mr. Chairman, and thank you, every one of your members, for your very careful attention. Thank you so much. Thank you. Thank you. Thank you.
Okay. Representative Gaddy, I believe, stepped out. Senator Walsworth is still in the chamber? No, yes. Okay. Who? Oh, Senator Boudreaux. Come on up.